and the belly up. We love coming here, and it's not just because we drink other than just water when we're up here. But we have short time, but we have a fabulous panel, and I'll briefly introduce them. Here on the drums and actually we have a bit of a problem because there are 3 lavalier mics, 1 handheld, so E.J. and I will be passing the mic. But E.J. is a columnist for the Washington Post. He's a senior fellow at the Brookings Institution. He teaches at Georgetown. You all know his articles. He's written a number of books. Probably the most relevant book to our discussion tonight is Why Americans Hate Politics, although I can assure you that E.J. loves politics. And next to him on lead guitar, Don Baer. Don is vice chairman of Gerson the global public relations firm. He's also chairman of one of the leading polling firms in the country, and he's had clients all over the world. He spent much of his career advising political leaders. As a matter of fact, he was instrumental in President Clinton's campaigns. He was the White House communications director for President Clinton, and also for a time President Clinton's speechwriter. He also was with Discovery Communications. And then on bass guitar is Mickey Edwards. Mickey is our own from the Aspen Institute. He served in Congress representing Oklahoma for 16 years, Mickey. As a Republican, he was a member of the Republican leadership. He currently runs the Rodell Fellows program at the Aspen Institute, which takes outstanding politicians, elected politicians around the country, and brings them to the Institute, talking about values and leadership. And he is most recently the author of Reclaiming Conservatism. And then singing, I guess? No, I'm not quite sure. He's the vocalist. Noah Feldman, polymath in the academic world, a professor of law now at Harvard, frequent contributor to the New York Times, including just recently the magazine. He has quite a lot of experience in not only constitutional law, but actually in writing constitutions. He was a key advisor to the Iraqis in the development of the Iraqi constitution. He was a law clerk to Justice Souter, and he's been the author of several books. He's also an Islamic scholar, and his new book will not be available, I guess, until the fall, but it's about President Franklin Roosevelt, and his Supreme Court. So our topic for this evening is, can the Constitution evolve? And we will look at that both literally in the context of actual change, actual evolution by way of amendments, and we'll also look at it in terms of changing interpretations and whether that's a good thing or a bad thing, and how it works. We will also probably make some references, especially Don, to a poll that we just officially commissioned by the Institute for the Ideas Festival about Americans' attitude toward the Constitution. I don't think we'll dwell on it too much because I suspect that probably only a few of you saw that presentation earlier today. How many of you actually did see it? So yeah, not enough to dwell too much on it, but Don will probably talk about that as it's relevant. But let me just, out of curiosity, start with a question. You know, the issue is, can the Constitution evolve? And the way the Constitution evolves, of course, is not by natural selection, but by amendment. And it's not really a very easy process. But let me just ask, and I'm going to take a look at hands, and perhaps exempting current law school students. How many of you can, and don't yell it out, I just want to see hands. How many of you know the last time the United States Constitution was amended, when the last amendment was ratified? How many? I expect like 90% of the people. I see maybe 2 or 3 hands. Well, that's an interesting lesson in civic education. But it's actually interesting.
An honest crowd.
It's a very honest crowd, and they haven't even been drinking. But quite seriously, and I think it's interesting, Would anyone care to take a stab at what the answer is?
Yeah, wasn't it the one that said we could all drink again?
Actually, it had a direct relationship to you, Mickey.
Would anyone like to embarrass himself or herself with a guess? Okay, in the back. Let me hear it. Just yell it out. No, not vice presidential session. Okay, I can't really hear, but I think I heard someone. Congressional pay raises. Correct. Give that woman a beer.
You know what? That's my wife. I have to live with that.
He had to live with it. But what's interesting about that, it was actually ratified and added to the Constitution. It was the 27th Amendment in 1992. And basically it said that members of Congress can't have their salaries increased or decreased until the next term. Well, to give you an idea of what the process is like, does anyone know when that particular amendment was first submitted to the Congress? 1789.
The first year of the Republic.
But let's start then with the Constitution in a literal sense. And for those of you who participated in some of what we've been talking about the last few days, a sort of a sub-theme that has come out at this festival, not surprisingly, is at least the perception of increasing dysfunction of our political system. And what I'd like to ask our panel, or any panelists who'd like to volunteer on this, is whether some of that dysfunction is actually a result of features of our Constitution or our failure to update it. And whether that's the gridlock that we all seem to complain about has something to do with it. And some people talk about the problem being the length of political terms, the fact that it's a constant campaign, which leads to the role of money and the power of incumbency, or maybe unequal representation in the Senate. And there are lots of other things. But let me ask the panel, and anyone can start, whether some of our problems today may be, in fact, a direct result of the system that's enshrined in the Constitution. Mickey?
I would say almost the opposite. The biggest problem we have in our political system today is the political parties, which were neither created by the Constitution nor envisioned by the Constitution, and which the founders, Madison in particular, opposed. And so in that regard, our system has grown in a way that the Constitution did not set out for us to operate it. And that's not a constitutional problem. That is something that's extra-constitutional and should have never happened.
Can I ask you why?
Noah.
I just want to ask Mickey, why do you think that's not a constitutional problem? I mean, I think I venerate Madison like everybody else, but he was against political parties and thought because he didn't like them, we'd never have them. That doesn't sound like good constitutional planning. Maybe the Constitution should have been written taking into account the probability that political parties...
Yeah, maybe. Emerge. I mean, he understood that there would be factions and that factions would be necessary. They were just in the nature of things, but he envisioned shifting factions so that you and I might be together on one thing, but we would be, maybe Don and I would be together on something else and against you. So, maybe he should have thought about that. They thought about a lot, but they obviously didn't think about everything.
And the reality is we have shifting factions. That is, in fact, what we have, except for the rigid party ideology that, in particular, its function in the Congress, in the legislative branch, and the extent to which that keeps the shifting factions from being able to find accommodation on a variety of issues.
Right. See, I disagree. Am I on? Oh, there I am.
Well, if you disagree, we're going to turn off your
mic. Mickey turned off my mic as soon as I said I disagree.
That's in the Constitution, actually.
I think parties are inevitable in a democracy. I mean, we started our country without parties. Madison is against them, though he later effectively joined one. As soon as Washington is president, no parties, no opposition to Washington, and instantly two factions that come to resemble and then become a political party gather around Jefferson and Hamilton. And they had principal disagreements, and I think it's natural in a democracy for people of like views to come together. Now, party systems don't always match the reality of current politics, and that's why the Whigs got displaced by the Republican Party, but that's not a problem with parties. But I do think there is a profound constitutional defect, and that is the United States Senate, which I think is an out. Yeah. Yes. Oh, no. I think the Senate is an undemocratic, antiquated body that should not exist in a country that claims to be a democracy. We have a Senate where Idaho and North Dakota have as many votes as California and New York. Now, this is nuts. I do not think, and somebody may correct me, that there is another democracy in the world that has a body that is so malapportioned in terms of representation. And we fixed the Electoral College, although I think the Electoral College is a flaw and also antiquated, and even though there were problems with it, I'm in favor of direct election. But I'm even sure that I would like a Senate that was far more representative or totally representative of the country by population. Why do we have such big farm subsidies? And why, for example, is the gun lobby so powerful? In Don's excellent poll, and by the way, in full disclosure, the people disagree with me about the Senate. They would preserve the Senate. But in his poll, the right to bear arms is rated as a very, very low compared to lots of other rights enshrined or allegedly enshrined, depending on how you read that amendment, in the Constitution. And yet we give disproportionate voice to rural states. I love rural states. I like to go there. I might even like to live in one. But they shouldn't be able to outvote the populous states in the country. So I think the Senate is a...
It was originally...
Right, and that was an improvement to me.
He just wants to go one step further. Noah has some comment.
Yeah, what I wanted to say is that a lot of the Founding Fathers didn't like the Senate either, but it was the result of a compromise and a historical accident of the way that people were arranged in these colonies that later became states. And the fact they were stuck with it is very characteristic of Constitution writing. You know, you run into these conflicts where it looks like the whole thing is going to break down, and this is exactly what happened in Philadelphia, and you need some solution. And what comes out is the Senate, or let's defer the question of Kirkuk until forever. I mean, that's the kind of game that gets played in these. And the problem with that is, once it's there, it's entrenched forever, and I don't think there's any way to change it now. So, I mean, even if I were to agree with you, and I'm not sure I don't, that it's totally undemocratic, we're stuck with it. That's not changeable in our lives.
We made the
amendment unanimous
process.
consent of the states,
of the states
who have two congressmen.
I think there's a definitional problem here. The system was set up not to be purely democratic. Our system is not to inject the will of the majority as controlling over all the people, but to protect the rights of the minority, as well as to empower the majority. And that's why you have these various other kinds of things in the system. So by having the Senate, I never thought, I was in the House, never thought I'd say a good thing about the Senate.
I drive you to that.
But the idea that the states that produce our wheat or our corn or our cattle or our oil or whatever have a bigger voice and an ability to have an influence on our public policy making is an important benefit.
So
the Senate was also intended, it was intended specifically to be anti-majoritarian for a reason.
Exactly.
It was meant to be, the cooling crucible?
Right.
The cooling
but it was
dish.
it was meant to be...
It was a buy-off for the small states so they'd ratify the Constitution.
Right.
And and just in terms of protecting minorities, we must remember that African Americans were declared 3/5 of a person in the original Constitution.
Right.
So that, and I think the trend in our history, correctly, has been to make the Constitution more democratic over time. The Civil War amendments did that. The Progressive Era amendments did that, except for Prohibition, which is a complicated case. And so I think our trend has been to make ourselves more democratic, and I think we should continue down that road, though I agree that the chances of getting that amended are very, very small.
Though, as you know from this poll that we did, 1,000 Americans done within the last month, by and large, they favor more democratic measures. I mean, the real bottom line message from this survey is when they talk about the Constitution, think about changes that they would be willing to adopt, they are looking for things that give more power to the people. Now, that may be a circumstance of the situation that we're in today, given the economic crisis and the like. They want to do away with the Electoral College by like 3/4, almost 75% say get rid of the Electoral College. They favor being able to amend the Constitution by direct referenda.
God help us all.
Yeah, well, there's some things that come through. The most shocking pieces of this, depending on who here is a lawyer and studied constitutional law, and by the way, in addition to everything else, I practiced law for 3 years, 5 months, and 3 days, Professor. So, the judiciary, talk about anti-majoritarian decision makers, the judiciary does not come in for a very good result here. The Supreme Court, they favor the election, 51% favor the election of Supreme Court justices. They favor mandatory term limits for Supreme Court justices and age limits for Supreme Court justices. But the idea of electing our Supreme Court, I think, is it's revolutionary.
Yeah.
Certainly not in the states, but at the federal level.
Although it came up in the progressive era. I mean, when Teddy Roosevelt ran for president in 1912, subjecting court decisions to democratic control, and the whole idea of electing judges, where in most states judges are actually elected. And I think the problem with that is not the election of judges, but the way that interacts with our campaign finance system. We saw recently in some controversies where over the coal company in Kentucky, where a judge, was it Massey Coal, had a case before the court, $3 million to beat an unfriendly judge, and then they won the lawsuit. They got thrown out by the Supreme Court.
It may well be that
but
the
it's not
Roberts Court recognized that the public was going to favor electing justices, and that's why they said corporations can give as much money as they want.
Yeah, that's a brilliant conspiracy theory.
But I hope Justice O'Connor isn't here because actually one of the things that she is now most committed to in her retirement from the Supreme Court is to try to get those states that still elect judges to stop that practice because it's horrific.
It's a
It's a
paradox.
fascinating issue because, as E.J. says, for actually almost 150 years, there have been regular trends in the United States, in the states, of people saying, let's elect judges. And it cycles through, and the states try it, and then they often realize they don't like it, not just because of campaign finance, but there's also data showing that as you get closer and closer to an election, you can't get your criminal conviction overturned. So then, whether you go free or not depends a little bit on when in the electoral cycle you committed your crime, or allegedly committed your crime. So I think, I actually think it would be a disaster if the Supreme Court were directly elected. On the other hand, term limits or age limits seem completely plausible to me, especially in a world where, wonderfully, people live longer and longer and longer. And although there have been some justices who did great work well into their 80s, they are distinctly in the minority, historically speaking.
Well, Noah, you've actually advised other countries on constitutions. I mean, we hold our constitution appropriately with such reverence. But first of all, it seems that the founder, certainly Thomas Jefferson, did not intend that this document would be immutable over time. I mean, he, in fact, thought it would be changed regularly and ought to be changed regularly. And as E.J. pointed out, it contemplated slavery. Yet it is so difficult. It is so difficult to change. What about other countries when they're looking to constitutions? They don't create the same kind of structure. It's not necessarily perceived as perfect a document elsewhere as it is today.
Yeah, ours is seen as extremely difficult to amend, first of all, which it is. And then we go through this process, and this goes to the topic of our conversation, where we change the Constitution without saying we're changing it. So Elliot spoke about amendment as a form of evolution, but actually, often it's the Supreme Court that changes the Constitution in practice.
Because what does due process mean? What does equal protection mean? Let's actually shift to that. And then I do want to make sure we have a short period of time, we have opportunity for questions. But let's just talk about this. This comes up, it's always an issue when someone is nominated to the Supreme Court. Noah and then others can comment. What are we to make of this notion of original intent, or the plain meaning of the language?
I think, and the poll actually talks about this, almost half of the people polled said they think the Constitution ought to be interpreted strictly. And I think originalism is imagined, and it was invented actually by Hugo Black, a New Dealer, a liberal, for the purpose of constraining the court, to keep them from going off the reservation and inventing new rights originally to protect corporations. But I think it turns out to be a false hope to think that by reading the Constitution literally according to its original meaning, you'll get to the meaning of it. because it's always controversial what the original meaning was. I mean, the gun case that we've just seen decide the second round of is a perfect example of this. So the Second Amendment says we need a well-regulated militia, and so we have the right to bear arms. Well, does that mean that because people once wanted militias, you can carry a handgun today? Or does it mean, in context, that it's good to have a militia to have a revolution every so often, as Thomas Jefferson believed, and so it's good to have, a musket at home so you can get together and form a militia and overthrow the government. I mean, there's no question what the framers believed between those two. It's the latter. That view is insane, but they believed it because they had made a revolution. So originalism doesn't get you to a definitive answer,
I don't think Justice Scalia would agree with you.
He claims not to, but somehow he reads the first sentence of the amendment entirely out of existence, which is funny for someone who claims that the text is everything.
But there's a difference between strict construction, which is, here is what the language says. And if the language is not something you support or think should be preeminent at this moment, you have means of amending it. But what he has proposed is originalism, which is mind reading. And that's very different. I think taking the originalist approach may be iffy, but strict construction saying, this is what it says. We have to have a common set of understandings about what our laws are, and we have means to change it if we think they're wrong. And I think that is perhaps a better idea than having whatever our Constitution and our laws mean dependent on which president got elected and which vacancies he filled and which people are now sitting on the court, so that our laws swing back and forth according to the political ideology of the moment.
I also think there's a difference between strict construction and reading the Constitution with your eyes actually open. I mean, I think it's remarkable, just to take the case of Scalia, that he just ignores the whole first part of the amendment. He constructs, in the original case, he goes on and on and on for page after page in a tendentious effort to pretend those words don't mean anything. And I think that first of all, I commend to everybody Noah's piece in the New York Times on June 21st called Imagining a Liberal Court. Answers lots of these questions. But I'm also, the other thing I would commend is Justice Souter's commencement speech at Harvard, where I think he made an essential point, which is the Constitution embodies conflicting values. And judges can't just sit there and pretend that there is some method called strict construction or originalism where clearly this only means a particular thing. They act as if it's a machine. And Elena Kagan said it well. She said that a robotic reading of the Constitution, it takes judgment to decide among these conflicting values. It's also the case that many things have happened that the founders never dreamed of, including our whole system of communications. We could go on and on and on. And you do want to have the country read the Constitution in a way that is consistent with its core values. But there is a great limit, I think, to how you can claim to come up with very clear answers about contemporary problems, by claiming that they're all there in the Constitution. They simply are not, and we have to make judgments.
Well, actually, just earlier this week on that very question, Jeffrey Rosen, who's a professor of law at George Washington, made a very provocative argument that if you look at technology today, and whether it's Google or whether it's other new generations of technologies of all kinds, communications, that looking 20 years ahead, the real risks to personal liberty, privacy, many rights that we take as sacred are not from government infringement, but actually from actions that would be taken by corporations.
Or others. And even though he wasn't one of the founders, Abraham Lincoln, I think, spelled out our situation pretty clearly when he suggested that this was a nation dedicated to the proposition that all men are created equal, and we have through the amendment process, because it wasn't perfect at the beginning, and we have through the amendment process and through interpretation in light of our current values moved in that direction. But he also said, that we were conceived in liberty, and that's the part that is more immutable. That is the part where it's necessary to make sure you don't give up those kinds of parts of the Constitution that, for example, made us one of those unique governments that doesn't have a head of government. We don't have a head of government. Most of the major powers, war, spending, taxing, are in the legislative branch. So, making sure that we don't lose that separation of powers and our belief in the protection of liberty is one part of it, and then doing the things that I know E.J. would hope we do, moving more and more toward equality is the second part of it.
Actually, E.J. mentioned your article, Noah, recently. Could you tell us what your basic thesis was? You say there's really a crisis in liberal thought, and you argue about how some of the real dangers that we face now constitutionally come actually from the powers of the market. And whereas much of our jurisprudence, well, I'll let you explain that.
Well, you said it better than I did. What I basically said in the piece is that for most of the last 50 years, liberal constitutional thought was focused on equality and liberty, and not very much on economic questions, the way it was, for example, during the New Deal. And we've kind of come to stalemates on those things. So, affirmative action, Justice O'Connor, in one of her last really great opinions, wrote a decision saying that affirmative action is constitutional for 25 years. And no longer. So that's a compromise position, a kind of stalemate compromise position. And the same is true on abortion, back and forth, back and forth. But because of the financial crisis, we now see that the big constitutional issues that are going to come in front of the court in the next decade are really about the economy. And they're about questions like, will the health care program be held unconstitutional? Will the financial regulators who are being put in place under the terms of the finance bill, the financial regulation bill that's currently in its last stages, one hopes, be ruled unconstitutional? And there, I think, we can see that the Supreme Court is very much, 5 justices at least, are pretty committed to the idea that corporations should have the same constitutional rights as individuals. And that's not the view of 4 of the justices. We saw this in the Citizens United case, which was the one that President Obama attacked the court on in their presence, which he was substantively right. I don't know how nice it was to do that to them. And it very much takes you back to the 1930s, where the Supreme Court was standing up strongly for the rights of corporations, but calling them the rights of individuals. And I think, it would be helpful if the justices would stand up, just say point blank, corporation is a wonderful technology. It's the greatest technology ever devised by man for consolidating wealth and increasing wealth, but therefore it's very dangerous when it comes to politics. And I think that's one of the lessons of the progressive era that E.J. was talking about before.
By the way, the poll shows that the public doesn't support the idea that corporations should have the same rights as citizens, human beings.
Right. Let me actually, we're about halfway through our time, so I could go on all night with these remarkable people, but let me give you all a chance. You're going to have to raise your. I see a hand just over the bar here, and this is all being videotaped and audio taped for the web. So please wait for the microphone and give us your name and then the question, preferably short question ending with a question mark.
Okay, I'm Elizabeth Sherman. I'm a professor of politics, American politics at American University, and I wanted to ask about your view of the legislation that was passed and signed into law in Arizona, and whether or not the law will be overturned. It's been challenged. It's been challenged.
Well, I saw a headline in the paper this morning that said, the local paper that said, Eric Holder says Arizona law unconstitutional. I don't know if he actually said that, but the local Aspen paper reported it.
He did.
Right here.
I think there's every reason to think that normatively it is unconstitutional, at least the way it sounds like it will be applied. The basic idea that there could be a discretionary decision on the part of a law enforcement official with no guidance in the discretion, that anyone that the enforcement official thinks might be illegal should suddenly be subjected to this kind of questioning and requirement of producing proof, does seem to give much too much discretion to the law enforcement officer. And I think in light of precedent, it's plausible to think that it'll be overturned. But the court would like not to overturn it.
It's more likely to be overturned on preemptive reasons, I think.
Yeah, I think the problem here is that the way they filed the suit was to claim that, federal supremacy. And I'm not sure that's the argument that would prevail.
And not to be
Contrarian?
To choose perhaps a bad word, slavishly devoted to public opinion, but...
you are a pollster, though.
Well, we know across the country, not just in Arizona, that the public, by pretty wide majorities, supports the idea of that law. So, I mean, I think it's been cited before that the Supreme Court is not immune to reading the latest election results.
It's been said, yeah. I mean, I think on the preemption issue, the claim that the state is somehow engaging in the enforcement of immigration law, it might be a winning argument, especially if the court wants to avoid the merits. But it's not obvious to me that that's a correct argument, because states do all kinds of things that have to do with, they have to process people, they have, they're engaged in a wide range of processes, and to take account of people's citizenship status is, in theory, something that they do every day. So I'm not saying it's not a winning argument. I'm just not 100% sure.
Well, not to get into the weeds on this particular subject, but I think it is pretty interesting. The real question is, given the constitution of the Supreme Court as it is likely to be constituted for the next 5 to 10 years, 5 to 4, what is likely to happen if it reaches the court?
I'm not sure this is one of those issues I could actually see one or more conservatives going over to the other side.
One.
And would only take one. No, yeah. I think this is not a clean-cut case for some of the conservatives on the court. And I think the preemption issue may be the strongest grounds, because if you look at the origins of the law, it is clearly designed to enforce federal immigration law. I am sort of, in general, uneasy with overturning the decisions made by Democratic branches, and I think it should be a very high bar. This one does seem to me, it does cross it in a number of ways, although I would much rather have the voters of Arizona repeal the thing.
All right, there's a gentleman in the second row. I may actually be closer with a microphone. Then we're going to go up there, then we're going to go to the woman in the front row.
In the spirit of a rock concert, we should bring him up here to dance with us.
All right. Well, thank you. My name is N.K. Singh, a senator from India.
I'm not talking about abolishing the Indian Senate.
Well, I mean, it would be slightly tough because its electoral college would really require ratification by all the states in India, and that system is really pretty democratic in multiple sense of the term. But no, we have amended our constitution a reasonable number of times. We did one 4 months ago, in which it requires a 2/3 majority in both houses of Parliament, the Congress and in the Senate. And the last time we did it was to make a compulsory reservation for women, 1/3 participation of women to be elected in both houses of Parliament. And that amendment went through, at least in the Senate. My question really is a different one, that one of the issues which is engaging Indian public attention is that given the fact that India has progressively embraced market-led paradigms, and secondly, the interdependence of the world in terms of the seamless transfer of capital, technology, and managerial skills, the fact is that our constitution has not kept pace with it, and it has resulted in a severe diminishing of the quality of parliamentary oversight on the functioning of the executive. That's why I wanted to ask any of the panelists whether any of this stuff is relevant to the kind of issues and debates which are taking place in the United States.
Well, first of all, let me just say that I really appreciate you being here. I'm going to be in India in about 3 weeks, and look forward to being back there. I don't know enough about your system, but I think whether it's empowerment of the executive or the legislative branches, I know the problems you face are so enormous. 800 million people who living on $2 a day or less. I mean, you've got a real problem, and you need to be empowered to take action. You need to have a system that allows, the kind of robust action by government to address those kinds of safety net issues and so forth. I don't know which way it would have to be changed because I'm not familiar with the Indian Constitution, but clearly I think something needs to be done.
I think to apply that situation to what is happening here in the United States, that in fact what we have is an 18th, 19th century system that's the original question, that may not be suited to the speed and complexity of issues that we have to deal with here in the 21st century. And I think that's a very big question. Let me give you one that we haven't even talked about. In the survey, citizens rate very high that they think the right to privacy should be highly protected by the Constitution, and certainly they believe that the governing authorities should respect that. Now, we are seeing, and we're about to see, I would say, a flood of questions about the right to privacy as relates to the Internet. The fundamental basis for Internet commerce is all about invading your privacy. And most people don't know it. Most people are not aware that Google is an advertising company, and that it makes the many billions of dollars that it makes, as do all other companies that are succeeding on the Internet economy, because they're taking information from you that you're actually willfully giving to them, but you don't actually understand that you are. This, we've seen this recently with Facebook. There's been a lot of call for some attention to what's actually going on Facebook and other platforms. Well, how do we cope with this as a democracy? How do we legislate? How do we regulate? In Washington today, there is a huge amount of confusion over which of the federal agencies, the Federal Trade Commission, the Justice Department, the Federal Communications Commission, or something that doesn't even exist today, should actually be dealing with these issues, much less what Congress will do about it. That's just one example of what is happening in the 21st century economy and culture and society that we're all living in, that our governing structure and the implementation of that really is not equipped to deal with at this point.
All right, I think there's someone back here with a microphone.
Yes, I too am a citizen of, I'm Vikram Raghavan. I too am a citizen of India, and I appreciate the earlier question in the exchange.
It's a sign of globalization.
Well, actually, I was going to ask a question, though, as a resident of Maryland. But just to sort of add a footnote to that question, actually, even though India has had over 100 amendments in 50, 60 years, the Supreme Court has exercised this extraordinary power of judicial review over amendments, which a dean of a U.S. law school describes as Marbury on steroids. But coming to Maryland, Mr. Dionne's paper had a great article last week about this Maryland requirement, one of 19 other states, well, one among 19 states, of requiring voters every generation to re-ratify a constitution. And they quote this very interesting letter from Jefferson to Madison, where he says that every constitution and every law naturally expires at the end of 19 years. And if it is enforced longer, it is an act of force and not of right. So I'm curious to know if that can be extrapolated at the federal level. Thank you.
I mean, I would say something about that. We mentioned Jefferson also earlier. He and Madison flatly disagreed. Madison disagreed with that letter. Jefferson thought you needed a revolution every so often so the dead hand of the past didn't control people. Madison thought that was terrifying to propertied interests and also to stability in the society. And luckily in my view, luckily for all of us, Jefferson was in Paris when the Constitution was drafted and wasn't able to exercise very much influence over it. What we do, though, is we change our system without fully acknowledging that we've changed it. So, when it comes, for example, to presidential control, the president has an executive agency that issues a moratorium on drilling in the Gulf. Now, a court just overturned that moratorium, but the bottom line is we do have these agencies that are in place to do this. There might be some debate about which one should do it. None of those agencies are contemplated by the Constitution, which says we have 3 branches of government, but we don't have 3 branches. We have 4 branches, and we've had 4 branches for 60 years. 60 years, that's a long time to be nothing like the way our actual Constitution was written. And that seems to work more or less all right for us, but one result is it gives a lot of power to the court.
Yeah, of course, George W. Bush tried to change that by declaring his view of the unitary executive, which suggested there was not a 4th branch, but that they all worked for him.
I just want to say that I live in Maryland, and I read that story. My wife is a lawyer, and we were talking about it, and I had utterly contradictory reactions to that. My first reaction was Jeffersonian. I think it's an excellent idea to have the voters re-ratify. And then my second reaction is, my God, at this moment, what will the voters do?
All right, I'm going to pass this to the front.
I'm Mary Torres from Chicago, Illinois, and I'm well acquainted with the dead hand of the past influencing elections. But what I'd like to ask,
right to vote in
that's right.
Illinois.
But what I'd like to ask is, since it's 2010 and reapportionment is raising its interesting head, This is something that I'd like you to comment on, how gerrymandering in a lot of the states and leaving that to the state legislatures, which may possibly be corrupt, how this is affecting our own ability to have our rights as voters enacted. And I'm very frustrated.
My first comment was about the political parties. And what happens now is the way the districts are drawn is that the Republican and the Democratic parties, these two private clubs seeking power, get together in the state legislatures and fight over what district lines will be to their advantage. And I think it's a real problem. And one way to get away from it is to require states to have independent, nonpartisan commissions that draw the district lines, because I think it has a very real effect on the outcome.
Well, let's talk about
do.
Let's talk about gerrymandering again from the poll. I mean, one of the things clearly people are upset about, and one reason that independents increase in numbers every year, is the increasingly and vitriolically differing views of the parties. And isn't gerrymandering one of the things that contributes to the fact that each party is increasingly captive of its either base or extreme, depending on your perspective?
You know, it turns out people have done some academic work on this, and it may actually have less effect than than a lot of people thought. You know, the idea is parties draw lots of safe districts to protect their people, therefore the incumbents are never worried about a contested election against the other party. They're only worried about a primary. If you worry always about a primary, you're inclined to worry about the base of your own party. Therefore, you produce Congress or a state legislature more extreme. It's not clear that that's as true as people thought, partly because we are actually naturally gerrymandering ourselves. I don't know how many of you know Bill Bishop's book. Right. Bill Bishop, a writer for the Austin American Statesman, discovered that we don't even like to live next to people we politically disagree with anymore. That what he discusses, for example, the number of landslide counties where even in close elections, the number of counties that vote more than 60% for one party or the other has just grown and grown and grown. You know, in my precinct in Bethesda, Maryland, we are very open-minded. Our precinct only voted 80% for Barack Obama. You know, and I'm sure I could find a precinct in Mickey's, Oklahoma, that voted that or even more the other way. So that because of those and other factors, gerrymandering, while there are problems with it on other grounds, may not be as much of a cause of that as we thought. Well,
let me just say, the name of the book is The Big Sort, S-O-R-T, by Bill Bishop, and you ought to read it.
Well, gerrymandering, you know, may not be, you know, it's not in the Constitution, although I think Elbridge Gerry signed the Constitution. I'm not sure about that. Maybe he did.
My dear home state invented the gerrymander.
You must be so proud.
Yes, well, I am. We're very politically innovative in Massachusetts.
But let's stay on that. Let me ask a question about what gerrymandering was raised. What other aspects of our structure of politics, whether they're constitutional or not, in your opinions, contribute most of all to the gridlock or dysfunction that many people see today?
Well, you know, it's interesting, and this is going to be an overbroad statement. Every one of them tends to be a mechanism that deprives the majority in democracy of being able to function efficiently. Gerrymandering, which is taking away from the people, from the public, the ability to decide who represents them as close as possible to where they actually reside. The filibuster, right? Where does that come from, and what is that about, and how is that even possible? You see, all these things have crept into the system, mostly because of political parties, which I agree with Mickey about. And you know, the fact of the matter is, they rob the public, they rob the people of the potential and the ability to govern themselves.
I think the 2-year time cycle for the House, I'd be interested to hear your view on this, is also a problem. You know, 2 years was an extremely long time in the 18th century, and they didn't even sit for a lot of that time. But with the media cycle that we have now and the way campaign finance works, it essentially requires more or less constant fundraising. And that, I think, affects, in light of the way our campaign finance works, really does affect the political agenda very powerfully, and it affects, even at an unconscious level, the power of corporations to shape in a very significant way the political agenda, I think, at least in the House.
Well, not just corporations.
Yeah.
I mean,
Not just
there's
other interest
another
groups as
big,
well.
there's
Other
another
interest
big
groups as well.
force out here called
Yeah.
organized labor
I
that has
agree.
an impact on
maybe-
I agree, but organized labor is
Not-
on the
doesn't have
decline.
nearly the
It
power.
is on the decline, historically speaking, in a way that corporations certainly are not.
And
Not in
maybe
terms of
even,
spending.
maybe even
Compared to
Noah, what
corporations.
about the 4-year term
was
of the
before
president
Citizens
even?
United.
I mean, now,
Yeah.
I mean, President Obama felt he had to do so much in his first year in part because of the realities of even the presidential.
No, but that was because of
very
2
few
years.
other, very few other,
That's because of
very
the
few
two-year
countries
House
that are founding a constitution now would opt for 4 years. Almost everyone would want a longer presidential term. That's perceived as too short a term.
Let me suggest one argument for, believe it or not, the 2-year term, even though that meant I was having to run every 2 years. When Ronald Reagan was elected in 1980, a number of the people who were part of his administration and some of the ones who were in Congress who came in with him misread that election very badly. There was a lot of reaction against Jimmy Carter, but they read that as an endorsement of let's turn to the right, which isn't what the public meant at all. And as a result, we started seeing things like Jim Watt banning the Beach Boys and, all this crazy stuff that happened. And 2 years later, the voters yanked the chain. And Republicans lost a lot of seats. And the voters were able to, bring us back more toward a sensible center. So there is some argument to be made for the 2-year term or even a 4-year term presidential election. It gives the voters a chance to make corrections in course, and I think that's a benefit.
Well, it's not just, we've seen it repeatedly. I worked in a White House in 1994 that experienced the same thing. We are likely to be seeing a White House this year that's going to have a similar experience.
I want to answer your question in a different way. I agree with Mickey, actually, on this one. In 1950, the American Political Science Association put out a report called Toward a Responsible Two-Party System. And the political scientists were frustrated with our strange party system because it was a kind of hybrid between the old system of the Civil War period, where you had part of the Democratic Party in the South being very, very conservative, parts of the Republican Party from the Northeast were quite progressive, and it just didn't match. And the political scientists longed for greater clarity so you could have decisiveness in government. And lo and behold, the political scientists have gotten what they wanted, because what we have had is an ideological sorting of the two parties where there aren't any Jacob Javitzes or Mac Mathiases or Ed Brooks or any liberal Republicans anymore. And there are certainly not really conservative Democrats like John Stennis or James Eastland and so on. So we have a real party system now that's more like a parliamentary system, but we don't have
a parliamentary system.
Yeah,
and
okay,
so we have a half a parliamentary system now, I think. And then the other issue, and Mickey can argue with me on this, I just think the Republican Party has become much more purely a conservative party than the Democrats have become a liberal party. If you look at the Democratic House, you've easily got 30 to 40 members who can safely be called moderate. Some are fairly conservative, though not as conservative as folks before, whereas it's almost impossible now to survive in the Republican Party. I mean, Senator Bennett of Utah, by my lights, I think by Mickey's lights, is a conservative, and yet he lost, he lost his seat in a party convention system. And I think that has created a much more difficult governing system.
I'm sorry, E.J., I love you, and you know
Just
that.
quick comment on that. I want to get back to the audience.
Here's my quick comment. I don't agree that in the Democratic Party you've got such homogeneity in terms of how the people who are in that party and in those caucuses really feel. Evan Bayh resigned from the U.S. Senate. It's a complicated decision for him, but one of the reasons was his deep frustration at having to work within the caucus. He was a moderate centrist who was come from a state that could be Democratic, but he saw no way that he could continue to operate. And Evan is someone's vocal who finally sort of stood up and said, I just don't want to do this anymore. There are probably 20 of them in that caucus. If they're candid with you and they talk to you about it, who say, I'm here, I don't understand how and why this works, how and why we are pushed to what they believe are extremes that they are pushed to. The same is true in the House. And here's what's more important. The country, we have the largest number of self-proclaimed independents in this nation
40%.
that we have ever had, 40%, and it is growing quickly. And that is, to me, a sign that we are stuck with a sort of the codification of a two-party system when, in fact, the country is trying to tear free from it.
Okay, we're going to go to this gentleman, and then I think there's someone back there with a microphone. Okay, thank you. It's hard for me to see.
I'm ready to go very quickly. I just want to talk quickly. My name is Chris Bryan. I practice law here in town. I would like to direct a question toward Professor Feldman, but I'd like to get the rest of the panel's input on this. It seems that the Constitution has some built-in elasticity in it, especially the 9th and 10th Amendments, and we see that very recently in yesterday's decision regarding declaring the Defense of Marriage Act unconstitutional there from E.J.'s jurisdiction there in the Federal District of Massachusetts. And I would like to just very quickly get Professor Feldman's input on that holding, which was 39 pages long, but it in large part bases it on 10th Amendment reasoning that a state that has legalized same-sex marriage would run counter to a federal statute that does not give benefits for same-sex marriages.
I should say preliminarily, I've only skimmed the opinion because I was here. But it is a remarkable opinion in that, as you say, it uses the 10th Amendment, which is typically thought of, because it protects states' rights, as a bellwether of conservative constitutional thought to achieve an outcome which is ordinarily would be perceived as a liberal outcome, namely striking down the Federal Defense of Marriage Act. Now, the question is, can states' rights be made that malleable? You know, if what's good for the goose is good for the gander, then in theory they ought to be able to be. But in fact, historically, there's been very little Supreme Court decision-making holding that the 10th Amendment actually does anything. And the same is true for the 9th Amendment. They've often been read by the Supreme Court as very minimal checks on the rest of the government, and invoked only under very unusual circumstances. So I will be surprised if it's upheld, but it's certainly a piece of creative constitutional thinking.
Can I add one very
sure,
quickly?
Mickey, and then a microphone in the middle here.
First
okay,
of all,
Scott.
shockingly, I want to agree with E.J. very, very much. I was in the Republican leadership, but neither Barry Goldwater nor Ronald Reagan could win a Republican primary today because neither one of them would be conservative enough in the definitions of conservatism that have come into being. But in terms of the 9th and 10th Amendment, not so much about states' rights, but also individual rights. When Robert Bork was nominated for the Supreme Court, I opposed him on the grounds that I thought he hadn't read the Constitution. Because the 9th and 10th Amendments, in fact, his opposition to Roe v. Wade was on the grounds that the Constitution did not grant us a right to privacy. However, we don't get our rights from the Constitution. We don't get our rights. You know, we were endowed by our Creator, and the 9th and 10th Amendments merely reiterate that as limits on the federal government's power. So, you know, I do think the 9th and 10th Amendments have a lot of relevance, and the fact that they're not being followed, I think, is one of the things that has fueled much of the resentment that is behind the Tea Party and a lot of other
Can I just say one quick thing? Thank you, Mickey, by the way. The one opinion I would love to read is Justice Scalia's opinion agreeing with the Massachusetts court in order to breathe life into the 10th Amendment. Now, that would be fun.
All right, the gentleman here in the middle.
Yes, my name is Larry Wolf. I'm a lawyer in New York, and I don't understand California at all. But can you comment on what they've done with the two-party system, in effect eliminating it by having whoever gets the highest votes get onto the...
Well, I know Mickey likes that.
Well,
I'm not sure all
Washington
of our
State has the
panelists do.
same thing. Louisiana had it for years. You know, they don't eliminate the parties because you have a right of free association, but they do take away the ability of these private clubs to have a small number of people get together and then limit who you can choose between in November. So that, you know, in Utah, well, you know, what, 1.5 million, 2 million people, and 1,000 or so people get together in a convention and say, Robert Bennett's not allowed to be on the ballot in November. You know, so I think the people in California had valid reasons to want to move in that direction.
A very quick thought on the two-party system. You know, we got our two-party system from England, the oldest first-past-the-post system, therefore mostly two-party ever. And as you know, in England, there's now serious conversation about having a national referendum about abolishing the first past the post system and adopting proportional representation. Now that happens to be because of the way this election came out there, but it's kind of amazing. I mean, if they can think about changing something that they've had for the better part of 1,000 years, it's not absurd that we would at some point imagine doing the same thing.
Okay, back here.
My name is Susan Silver. I came in a little late, so I don't know if you've dealt with this question. I watched the Kagan hearings, and it seemed that there was a big preoccupation on the right about activist judges. It seems, however, now that this court seems to be the most activist that's ever been. Is it just a question of whose ox is being gored or what?
Amen to your question, although I must say what struck me about the Kagan hearings is that Republicans seem to be backing away from the term judicial activist. Perhaps they felt slightly guilty about what was going on, but I think they realized that the new fight is really about conservative judicial activism. So the new term of art is results-oriented judging. Now, well, I mean, Bush v. Gore. Try that one. I can't think of a more results-oriented case. This case doesn't apply to any other election but the one to George Bush. But anyway, I mean, you're exactly right, and I think that the, Noah and I were talking before the panel. I think that you are seeing for the first time in a long time some real success on the part of progressives to begin to change the judicial conversation. I thought that Justice Souter's speech at Harvard was very important. I thought those hearings were important because if you compare the hearings for Kagan with the hearings for Justice Sotomayor, in Justice Sotomayor hearings, the Republicans were very effective at controlling the entire dialogue. And in the Q&A, it almost sounded like Sotomayor was Justice Scalia. She never lied, but it was sort of, if you follow it along, whereas this time, Democrats were organized, which is often an oxymoron, and made an aggressive case on behalf of a different approach of the dangers of conservative judicial activism, raising the issues of corporate power that Noah raised. So I think this argument is beginning to change, and the fact that the conservatives backed away from the term judicial activism, I took as a modest good sign.
There's someone in the far back.
Hi, my name is Celeste Middleton. I'm from Austin, Texas. And we've been talking a lot about areas for change and areas where the public is frustrated with the Constitution. And my question is, given the disparity between public opinion and political action, do you think that the next big changes to the Constitution, such as equal rights for women, will come incrementally, as with like the gradual incorporation of the Bill of Rights via the Due Process Clause? Or do you think we really need something like the 14th Amendment to fuel that change? Where is it going to come from?
I mean, that question was a very live and important question on this question of women's rights, 35 years ago when the Equal Rights Amendment was before the country. And when it didn't pass, what we got instead was the incremental adoption of equal rights for women. I mean, I think today, of the rights called for by the people who supported the ERA, almost all are now treated by the Supreme Court as constitutional law. And the same is true to some extent, though not fully yet, for gay rights, where the adoption process has been incremental and slow and still not there all the way, although I think it's quite probable that it will get there eventually. So, I think when there's a big national movement, it can come close to doing it the way that you described, but when it fails, you go to the other option. And so motivated movements will try to change our Constitution using any means available to them.
Just going back to the poll for a moment, because we may be close to use a cliche, one of those tipping points with regard to your question. We asked a series of rights and whether or not people think the U.S. Constitution should guarantee those rights. And the leader, by a pretty wide margin, the right to equality regardless of gender, 70% of the respondents. And by the way, it was not in the first tranche, but the right to equality regardless of sexual orientation at 55%. So Probably 5, 10 years ago, you would not have seen a majority of people who would have responded that way.
Okay, and unless we are going to have this panel actually playing the instruments, we have time for just two very quick questions. Right here and right there. Why don't we just get your questions quickly, and then we'll have quick responses, because we do have to let the real band come in.
Richard Gordon, Aspen, Colorado. Unfortunately, the recent California initiative does not weaken the Democratic or Republican parties. The concept of a general primary with 2 candidates only emerging for the general election enshrines the Democrats and the Republicans. It eliminates the Libertarians, the Conservatives, the Greens, the Socialists, and all the other parties, because only 2 candidates will emerge from the primary. So rather than having the purpose that you hoped that it would, and which was never really explained to the California electorate, and the reason that it passed is the Democrats and Republicans love it. They will no longer have to worry about attacks from, say, Ralph Nader, or people like him on the Green side, or on the conservative side. They'll be gone in the primaries. I wonder what you all think of that.
Okay, thank you. And before we ask them that, I think I've seen, yes, the gentleman right behind the bar.
Hi, Larry DeGeorge. Just to comment on what Noah had suggested and some of the other comments that were there on the judicial activism issue. In my opinion, one of the biggest threat to the Constitution is the fact that law schools embrace and encourage judicial activism by the study of case law. And to my way of thinking, while Noah's example of the IRA is a positive one, I think you can find numerous examples, and the purpose of my comment is I view that as a serious threat to the evolution, if you will, that's been proposed here, or a mechanism for the evolution that's been proposed here, which circumvents all of the checks and balances that we have for modification of the Constitution.
Okay, thank you. Let me just ask each of our panelists then to respond if they care to either of those questions, or any just closing comment on the general themes that we've heard tonight. Who would like to start?
Well, let me say about, in California, it might be true that what you end up with is the Republican and the Democrat. It could be very, Louisiana had that system for a long time, and you might often have 2 Republicans in the general election and no Democrat, or 2 Democrats and no Republican. And because the parties would not be able to weed out the players and limit who could be on the ballot in November, you might have several candidates on the ballot. You wouldn't have to have 2. You could have 5. You'd have to have, each state would have to have some means of making sure it wasn't 205. But there are ways to do it. Now, I'm not really familiar with the language of the California proposition, but the idea that you eliminate primaries, the idea that you take away from the parties the ability to choose who the nominees will be is a good thing. Whether the California way of doing it is the right way or a terrible way, that I don't know. But I'm very much in favor of not letting the parties control who we get to choose between in November.
And any other?
The parties themselves didn't like this amendment. I think they actively opposed it. In principle, this would allow the Libertarian, if he came in second, to get on the ballot. In Britain, the reform they're talking about is called the alternative vote, which is intriguing, especially for third-party supporters, where you number the ballot. There's also, in Australia, the single transferable vote, where you number all the candidates. If you say you number 1, 2, and let's say you vote for the Libertarian, your guy or woman doesn't come in, your vote is transferred, your candidate comes in last, that vote is transferred to somebody else. It is a way of allowing people to vote for third parties with less risk. I just want to say one other thing on the larger constitutional issue. I have been sort of thinking a lot about this because of a book I'm writing, and I've been sort of back in the days of the founders. And what's really struck me looking at them and looking at that history is they were ingenious. They were, what they produced was remarkable, but they were politicians. and that this document reflected compromises. And while we should respect what they did and admire them, I don't think we should deify them or pretend that we in our generation, this is a very Jeffersonian thought, that we in our generation are not capable of perhaps thinking new thoughts that might be a little better than theirs, because they were revolutionaries who thought thoughts that a lot of people had never thought before.
Thank you.
I agree. I want to
Don, and then we'll give Noah the last word.
I want to build off of what E.J. said and associate with it completely. And I think we need to recognize that not only were they politicians, they had imperfect judgment. 500,000 Americans had to die in order to fix the greatest flaw in the Constitution as they wrote it, which was in the Civil War, not to mention generations of people who were enslaved or the people who came after them who were enslaved, and we are still dealing with that imperfection. We made reference to the 2000 presidential election without being partisan in any way whatsoever. Our constitutional electoral system failed. It utterly failed. We could not select a president as a democracy in the year 2000. That's frightening. And we've had other ruptures along the way, all of which suggest that it's up to us in our generation and in the generations to come to find the remedies, make the fixes, and perhaps be as revolutionary as they were in their approaches.
Noah.
Well, I think that we have actually changed our Constitution enormously over the last 200 years. The president has a lot more power than he once did. The legislature, through putting into place agencies and other things, has changed the structure of the Constitution. And the Supreme Court is wildly more powerful than it once was. Now, the question is, are those good developments? And they may not be. And it may be that what we teach in the law schools does facilitate that. But when the rest of the world looks at us and they say, how can you still have the same Constitution 200 and some years later? The answer to that, of course, is we don't have the same Constitution. We just have the same piece of paper. In fact, we've changed the Constitution drastically. It's just that the way we do it is we pretend we haven't done it. Right. And that, in some way, that seems extremely un-American, right? We're supposed to be the honest ones around the world. But in fact, when you go out and draft constitutions, you see the Americans showing up and saying, our Constitution it's great, you should do it the way we did 200 years ago. And I look at them as if to say, you are crazy. No one should do it the way we did 200 years ago. It would never work. It didn't work that well then. It led to a civil war. I mean, we got about 65, 70 good years before we got a civil war. So, you know, the bottom line is that these are the mechanisms we have developed to evolve the Constitution. And they're very imperfect, but we're committed to them in part because we believe that we have the same Constitution we always had and we just don't.
Ladies and gentlemen, let's thank this wonderful panel. Thank you.